Got a joke for you. What do you get when you mix one appointed judge by Clinton, one appointed judge by Obama, and one appointed judge by G.W. Bush? You get a bad decision. Let's go ahead and talk about it. What's up, Wolverines, and welcome back to my little piece of paradise known as John Crump News. On this channel, we talk about everything 2A related. I'm your host, John Crump, and today we're going to be talking about a case out of Florida, which is the National Rifle Association versus Bondi. This case challenges Florida's ban on people under the age of 21 from owning firearms. The law came to be after the Marjorie Stoneman Douglas mass tragedy where a bunch of kids lost their lives to a maniac with a gun. The law was a knee-jerk reaction to that, and it should be repealed. In fact, there is a bill to repeal that law right now, but it has not passed. If HB 1543 does pass, it will revert the age to transfer or buy a firearm from 21 to 18, which is where it was at before a bunch of turncoats led by Will Stimson passed a bunch of anti-gun bills in Florida. But as of now, you cannot buy or transfer a firearm in the Sunshine State if you are under 21. The NRA sued over that, and that case has now went to the 11th Circuit Court, where a 3-judge panel ruled on it. Now, this is a Second Amendment case, so the judges were bound by the Bruin decision, and they did some real mental gymnastics to get to where they were. Bruin says you have to use the literal text of the Second Amendment and the history of the Second Amendment in applying the Second Amendment to cases. So this is what they did. They said an analog is not exactly a direct copy of it. It is something like it. But you can't even find an analog back in 1791 when the Second Amendment was signed. So instead of looking at when the Second Amendment was signed, they looked at when the 14th Amendment was signed, which is 1868, which is a long time after 1791. In 1868, there was a period called Reconstruction. And during Reconstruction, guess what was passed? A bunch of racist Jim Crow laws. So what they did is they used these racist Jim Crow laws as their basis to say that this is constitutional, not because it was constitutional when the Second Amendment was signed, but it was constitutional in 1868 when the 14th Amendment was ratified, which is ridiculous, and it's just them looking for an excuse to strike down this lawsuit. They claim they used the ratification date of the 14th Amendment because that is when the Constitution said that the Second Amendment and also the whole entire Bill of Rights applies to the states, which is ridiculous, and it's just cherry picking some facts to try to find a way to uphold the unconstitutional Florida law. Now let's go ahead and talk about what could happen and what probably will happen. The NRA will ask for an en banc hearing of the 11th Circuit Court of Appeals. An en banc means the whole bench will hear the case and decide it. If that is granted, the 3-judge panel decision is vacated. It is like it never happened. And everyone would go in front of the whole entire 9th Circuit and argue the case. And there's a good chance the 9th Circuit will rule for the NRA. Now, after that happens, and let's say the NRA loses, or even if Florida loses at that point, it could be appealed to the Supreme Court, and the Supreme Court can choose to take the case. And if they choose to take the case, they will decide on the constitutionality of the Florida law, which would affect the whole nation, or they can just decide not to. Now, if they decide not to take the case, which would be denying a writ of certiorari or a writ of cert, then whatever the 11th Circuit Court of Appeals decides will stand. This case is far from over. I do believe that the 11th Circuit Court of Appeals will grant an en banc hearing to this case. And also, I believe no matter what happens, that this case will be appealed to the Supreme Court. Whether the Supreme Court issues a writ of cert or not, that is up in the air. I cannot say either way, because anyone who says they know what the court is going to do has no idea about the legal system, because no one ever knows what the court is going to do. It's just the way it is. Sometimes they grant it, sometimes they don't. And there's no really rhyme or reason for them to grant stuff and to deny stuff. It's just what they do. The court system is very, very confusing. I will end by saying what we are seeing is the slow death of gun laws. These activist judges are making a last stand. We are seeing it here, and we saw it the other day in the Cargill case. The Fifth Circuit Court of Appeals told the district judge he had to enter a judgment for Cargill and grant appropriate relief. The district judge granted a judgment for Cargill, but didn't specify any relief, leaving everything in the gray area. The Cargill case was the case dealing with bump stocks. So we're going to have to see what Cargill and his lawyers do. I did speak with Michael Cargill, and he said they have something planned, but they're not willing to share that right now because they don't want to tip their hand, which is probably a smart idea. Bruin has really changed the landscape, and all gun laws are dying a slow death through the court system. These activist judges are going to try to uphold them as much as possible, but in the end, they will be defeated. It's going to take time because the court system is incredibly slow, but it will happen. And that should give you hope, and it gives me hope. All right, guys, that is it. Stay ever vigilant, stay ever free. Go ahead and like the video. If you like what I do here, like, comment, and subscribe. I'm working on some really, really cool stuff that you're going to see pretty soon, and I think you'll be happy with it. But until then, I love you very much, and Wolverine's mother...